So, in the course of me shooting content of family law over the years, my dear audience, you guys have posed so many questions to me, and some have been able to answer, while some still remain pending, and they're still awaiting answers. And some people, if they are so adamant on getting answers like that, they even go straight to my DM or they repeat the question over and over again. It's not my fault. We have a life, we have a law practice outside social media, so I try as much as possible to do videos to explain extensively in answering these questions. However, of course, some questions still remain pending and I've not been able to answer them. So I've taken it upon myself now to address these questions. I mean, I went to revisit my video from the very first video I posted on family law on TikTok, actually. Yes, on TikTok, because I post primarily on TikTok, right? So I revisited from my very first video, and I started picking out those questions that I have not answered, and I have taken to myself that I am going to start answering this question. So from this video and subsequent videos, I'll be answering questions that have been posed to me on family law in Nigeria, from custody, divorce, maintenance, settlement of property, which is the subject matter of today's video. Yes, settlement of property. And I'll be answering these questions as we go on. Okay, so what I need you to do is to like, subscribe to this channel, and turn on the notification bell to get more videos on family law in Nigeria, okay, so that you can be notified when I drop a new video. This page is all about family law in Nigeria. Family law. If you want to know about family law in Nigeria, if you have questions, this is where you should be. So like, subscribe, and turn on your notification bell to get notified when I drop a new video. So in answering today's question, let's just go straight into today's video. Let us answer the question for today. And the question is this is how the person actually posed the question, and that is how I'm going to read it out and address it. If I buy a land before I marry, then build on the land during marriage, who owns the property during divorce? Very interesting question. Very interesting. And this is a classic issue in family law. However, a question like this does not have a straightforward answer. Oh, the buyer is one that owns the property, the wife or the children. There is no straightforward answer to this question. I'm going to start by this. The law that regulates dissolution of marriage in Nigeria, including settlement of property during divorce, is the Matrimonial Causes Act. That is the law that regulates it. We're going to be referencing a section of the Matrimonial Causes Act in order to answer this question. Remember, I said this is not a straightforward answer. So we're going to be using a section of the Matrimonial Causes Act to answer this question. And that section is section 72 sub 1 of the Matrimonial Causes Act, which empowers the court to require the parties or either of them to make a settlement of property to which the parties are entitled. Note that word, entitled. To which the parties are entitled for the benefit of the parties and the children, as the court considers just and equitable in the circumstance. Did you get that? That is the provision of section 72 sub 1 of the Matrimonial Causes Act that talks about settlement of property. Remember the word I asked you to know, right? Entitled. To which parties are entitled for the benefit of the parties and the children. So this should tell you that settlement of property is not automatic. It is not 50-50, 70-30. It is not automatic. You don't, just because you are the spouse or just because you are a wife or you are a husband of somebody, doesn't guarantee an automatic ownership of property. So the fact that you are married to somebody or you are a spouse does not automatically guarantee that you're going to have a share or a certain percentage of the property. The section says entitled. So it means that you must be entitled to that property. You must be entitled to it. It's not automatic. And how do you show that you are entitled to it? Or how do you show your entitlement? That is where evidence comes in. That is where you have to prove to the court that even though, yes, I conducted a statutory marriage with this person, I am entitled to this property. And you have to prove to the court through evidence, through whatever it is, through evidence actually, to prove that you are entitled to a certain percent or any part of the property. Remember, even the property, when it comes to settlement of property, it doesn't have to be real estate alone. As long as it belongs to one or either of the parties, you can prove entitlement to it. Do you understand so far? So entitlement of property is strictly by proof. It is not automatic. So the fact that you're married to somebody does not guarantee that I must, or to show is sure for me. I'm going to get it. No. The section says, Section 72(1) empowers the court to require the parties or either of them to make a settlement of property to which the parties are entitled. You must be entitled to it. And entitlement is by proof. Okay? Let's go on. Now, let us consider the later part of that section. That's same section 72(1) of the Matrimonial Causes Act. The later part says that as the court considers just and equitable in the circumstances. So, in as much as you have to show proof that you're entitled to the property, the court also has the discretion to act just and equitable, to determine what is fair in the circumstances presented. Based on the circumstances of the case, the court also has the power, also has the discretion to determine what is fair and what is just when it comes to settlement of property. That's why I said it's not automatic. It's not automatic. You have to show proof, and of course, the court still has the power to decide. So it's in the hands of the court, actually. It is just in the hands of the court, because even when you show the proof, you have to convince the court, and the court has to show that, okay, I am convinced that you're the owner, I am not convinced you're not the owner. It's still in the power of the courts. So this later part of this section actually gives the judge the discretion. It gives the judge the discretion to decide based on the fact of the case presented. Okay. Now remember that we are answering a particular question. There's a way we answer questions. There's a way we answer questions in law. You have to state the rules before you apply it to the fact of the case. Okay. So right now I am reading the law, the rules that I applied. Then I will apply it to the fact of the case that have been presented that we are addressing today. Generally, when it comes to property acquired during the course of a marriage, it belongs to the spouse whose name they acquired, right? That's why I will tell you that if you want to acquire a property, probably you contributed as a man, as a woman, make sure your name is on the documents and not just Mr. and Mrs. Your full legal name, Mr. James Peterson, Mrs. Beatrice Peterson, your government name. If you changed your name to that of your husband, then your recent name, your new name, okay? Just make sure that it is your full legal your government name that is on that document. So generally, property acquired belongs to the spouse whose name they acquired. So if the property was acquired by the man and his name is on the document, it belongs to the man. If the property was acquired by the woman and her name is on the document, it belongs to the woman. If it was acquired by both of them and both their names are on the document, it belongs to the both of them equally. That is the general rule. That is what applies. So the fact that you are married to your spouse statutorily, does not automatically make you a co-owner. If you want to have a right, if you want to have interest over that property, your name, the property must also be in your name. If the property is not in your name, and your spouse was not that bought it, but your name is not on that document, it does not belong to you. So you cannot say, yes, so he's the one that bought the property, but because I am his wife, it also belongs to me. My dear, if your name is not on that property, it does not belong to you. It is presumed that the law will look at the legal name on that document, and that is what will be presumed. The law will presume that the person name on the document is the owner of the property. You cannot co-own something when your name is not there. So if you want to have an interest in the property, your name has to be on that property. So automatically, there is no automatic ownership. That's what I'm trying to explain. There is no automatic ownership when it comes to property acquired during a marriage. So as the spouse of someone that acquired a property, your spouse acquired the property, but your name is not the document, but you want to claim interest in that property as well. Remember, I said generally it is the person in whose name the property is acquired that is presumed as the owner. But when can you claim a share in the property, even though your name is not on the property? That is where proving entitlement comes in. Remember entitlement that I explained? That is where proving entitlement comes in. Yes, your name is not the property. It was not you did not acquire the property, but you still want to show that you have a claim, you have an interest in it. You have to prove that you are entitled to it. You have to prove a certain contribution that you made, either when so maybe he acquired the land, but I contributed financially, I contributed by other means. So you have to show proof that you contributed. That is when you can lay claim to a share in the property. Did you understand? So if you can produce credible evidence, legally admissible evidence to show that you contributed to that property, you can lay claim to it as well. Even though your name is not even on the property, you can lay claim to it. So that's what we'll ask when people come for consultation. My husband did this property, what is my interest, what is my duty? And the question is, what contribution did you make? What contribution did you make in that property that you are laying a claim to? Did you contribute anything at all? Do you have proof to show? Because another issue is, even though a spouse might not have acquired the property, or the name of the spouse is not on the document, but they contributed significantly to seeing the reality of the property. They contributed as well. But the issue is where they can't prove it. Some of these things are not usually documented. They are not usually recorded. Most people don't really take record of it. They don't keep it. I mean, during that time, although they were in love, so nobody is going to think that let me keep it or in case, because that's not the mindset. Also, I mean, if you are entering a marriage, you shouldn't be doing in case. You are in it for life. But as it stands, we know that sometimes marriages and relationships tend not to work out, and most of the times during the period of contribution and acquisition of property, there is no evidence. It was not kept, and it will be so hard to prove your case if you cannot prove that you contributed. So if you want to lay claim to a property, you should be able to show that you contributed. If you want to be entitled, remember entitlement, right? If you want to show entitlement, you must be able to show it by evidence, proof that you are entitled to this thing. And I think I've said it here that contribution does not necessarily mean to be financial. Even non-financial contribution can stand as well. But the issue is, how can you prove it? How can you prove it? People tend not to keep track of these things. They tend not to have the proof, the evidence to show their contribution, and that is where the contention is. That is where the issue lies. Now, there's a 2002 case where the woman was laying claim to. It's a real life case. It's a case that was decided by the courts. The woman was laying claim to the matrimonial home, claiming that they both owned the matrimonial home. However, the title documents were in the husband's name. And the woman said that the reason for that is so that the man might be able to facilitate a loan, okay, to complete the building. That was why the title document was in the man's name alone. But they both owned the house. The trial court believed them and went ahead to, give her a share of the property. They divided the home. But on appeal, the man appealed that decision. The man appealed it, yes. On appeal, the appeal court held otherwise and held that since the property was in the husband's name and the wife has not been able to prove entitlement, to prove that she indeed contributed to the acquisition of the property, order, the trial court judgment to divide the property was set aside, and the property was given to the man alone. The man was declared the owner, and that the woman does not have any rights, any claim, any interest to that property. The appeal court held that word of mouth does not override title documents. You see that title documents? That is what they can see. That is the tangible thing that could be seen and can be believed. So once that title document was presented and it was the man's name alone that was on that title document, the court held that it is not enough to just say this home is ours. Yes, I contributed to it. You must be able to prove it. You must be able to prove entitlement, the contribution. And since the court was not convinced, obviously the woman was not able to prove a contribution to the satisfaction of the court. The court held otherwise, set aside the trial court judgment, and held that the man is the bona fide and only owner of the property. And that's it. So when it comes to especially real estate, you see title documents, it is very important. It overrides oral statements. It overrides oral agreements. You must be able to show it convincingly. Okay? It's just in rare cases that remember the later part of the provision I read about the court being just and equitable when it comes to marital settlement, right? Yes, in some rare cases the court can actually, in the interest of justice and fairness, can be fair. In some rare cases, even though one spouse cannot really show a contribution, in the interest of justice and fairness, the court will still find a way to protect that spouse's interest, especially where there are children involved. Okay, this is where equity comes in. Even though the other spouse, let's say the woman, for instance, because the woman in this part of the world, the woman is usually is the woman that gets the shorter end of the stick. Anyway, so because of the children, right, the court can protect her rights in other ways. Okay, for instance, let's say the court can say, you know what, let the woman remain in the house. It should not be sold. Nothing should happen to the house. The house should remain like that. Let the woman continually live in the house and her children. So she might not actually have interest, but she should not be thrown out. So that can be it. That can be a decision of the court. So the husband can be restrained from selling it, but she will remain in the house with the children. Equity, just and fair. So let's bring it back to the question, the very first question, the question that we are addressing, the purpose of this video. Let's bring it back to that question that reads, if I buy a land before I marry, then build on the land before marriage, who owns the property during divorce? Now, based on the explanation I just gave, what do you think the answer is? Okay, let me help you out. Who owns the land? The man, right? He bought it before marriage, so he owns the land. But he said that it was constructed during marriage. he got married and he started building on the land. Now, this is where it gets interesting. A house built during the course of your marriage may be considered a marital asset, especially if your spouse contributes to the building of the house. Okay? If your spouse contributed to the building of the house, it can be considered as a marital, it can be considered as a matrimonial asset, especially if she contributed financially, or while you are using your money to build the house, she's using her money to take care of the family. That's a contribution. Like I said, it doesn't have to be financial. It doesn't have to be financial. While you are focused on building the house, she's using her own money to take care of you and take care of the house and take care of the children. That means your responsibility that you're supposed to fulfill at home, she's carrying your responsibility together with her own while you are focused on building your house. That is a valuable contribution as well. So in that instance, it may be considered as a matrimonial asset. So in this case now, the court will not just look at who owns the land. The court will look at what contribution. The court will ask you to prove that you are entitled, and of course your spouse will want to prove that she is also entitled to the land as well. And if she can prove that she indeed contributed to acquiring that, to the building of the house and, you know, raising the structure on the land, she will have a claim on that property. She will have a claim on it. Yes. So there is no, you are the owner, she is the owner. The court will determine based on the circumstances, based on the evidence provided, and based on everything to decide who gets what and who gets what. So buying land does not automatically protect your rights over the property. If it was developed, if it was built during the course of your marriage, and your wife can prove contribution, you alone do not have automatic rights or interest. If she can prove contribution, she also will be compensated as well. So you may own the land, but if the house was built in the course of the marriage and your spouse can prove that she contributed to it, your spouse may have a claim as well. Okay, that is Nigerian law for you. This is not automatic. That is Nigerian law for you. I hope I've been able to answer this question, and I hope you've been able to learn one or two things. Like this video, subscribe, and share as well to as many people you think that needs to see this video. Okay, and don't forget to turn on your notification bell so that when I drop a new video, you will be notified. This page is all about family law in Nigeria. We discuss family law in Nigeria, and if you have any question as well, you can just drop it in the comment section and I will do an extensive video on it, just like this one. Okay, remember I said I am answering questions that have been posed to me over time that I've not had the time to respond, and I have taken it upon myself to answer this question. So if you have questions, you can also drop it in the comment section and I will just add it among my list of questions that I have to respond to. I will see you in my next video. Bye.